Welcome to Behind the Lines, coming to you from the socialist, Marxist lines of Washington State. It's a crazy liberal petri dish for the rest of the country, folks. Stay up to date with all the great news right here. So yesterday, February 25th, 2021, the Washington State Supreme Court has decriminalized felony drug possession. In the case of State of Washington versus Shannon Blake, Supreme Court case number 97873-0, they say Washington's strict liability drug possession statute, RCW 69.50.413, makes possession of a controlled substance a felony punishable by up to 5 years in prison plus a hefty fine, leads to deprivation of numerous other rights and opportunities, and does all this without proof that the defendant even knew they possessed the substance. This case presents an issue of first impression for this court. Does the strict liability drug possession statute, with these substantial penalties for such innocent, passive conduct, exceed the legislature's police power? The due process clauses of the state and federal constitutions, along with controlling decisions of this court and the United States Supreme Court, compel us to conclude that the answer is yes. This exceeds the state's police powers. And it says we begin with the rule that state legislatures have the police power to criminalize and punish much conduct, but the due process clauses of the state and federal constitutions limit that power. The key limit at issue here is that those due process clause protections generally bar state legislatures from taking innocent and passive conduct with no criminal intent at all and punishing it as a serious crime. Unfortunately, that is what the RCW does. The strict liability felony drug possession statute does, and it is the only statute in the nation to do so. We therefore conclude that it violates the state and federal constitutions. So this case originates from 2016, where police executed a search warrant in Spokane, Washington, seeking evidence of stolen vehicles. They arrested 3 people on the property, including Shannon Blake. And at the jail, a corrections officer discovered a small baggie containing methamphetamine in the coin pocket of Blake's jeans. The state charged Blake with possession of a controlled substance in violation of the RCW. At trial, Blake relied on the judicially created affirmative defense of unwitting possession. She testified that a friend had bought the jeans secondhand and given them to Blake 2 days before Blake's arrest. Blake said she had never used methamphetamine and did not know the jeans had drugs in the pocket. She acknowledged that the drugs had been on her on the day of her arrest. Blake's boyfriend also testified that Blake did not use drugs and that she had received the jeans from a friend. So their analysis is the strict liability drug possession statute exceeds the state's police power by imposing harsh felony consequences on innocent non-conduct with no mens rea. Mens rea is Latin for guilty mind. It is the mental element of a person's intention to commit a crime or knowledge that one's action or lack of action would cause a crime to be committed. It is the necessary element of many crimes. They say Blake clearly argued that the Constitution bars the legislature from penalizing her conduct without requiring the state to prove she had a guilty mind. And then the justices question whether the legislature possesses the power to punish Blake for innocent conduct, or more accurately, non-conduct, without proving any mental state at all. And they go on to say that police power is not infinite. If it were, the result would be a police state, and the legislative branch of the government would be omnipotent. I think we're already there on that one. So then they go on to compare this sort of crime to curfew violations or homeless people violating staying in a city without registering. These are old laws, but it goes on to say that the second constitutional limit, the rule against criminalizing essentially innocent conduct, does not have such exceptions, and it applies with special force to passive conduct or non-conduct that is accompanied by intent, knowledge, or mens rea. The United States Supreme Court explained this over 60 years ago in Lambert versus California. Los Angeles had criminalized remaining in Los Angeles for a period of more than 5 days without registering with the city. A defendant charged with violating this ordinance was given no opportunity to comply with the law and avoid its penalty, even though her default failure to register was entirely innocent. The United States Supreme Court held that this exercise of the police power to criminalize entirely passive, innocent non-conduct deprived defendant Virginia Lambert of her liberty without due process. And they go on to cite a similar one in Florida of night walking. If you were walking with a juvenile outside after 10 p.m., you could be criminally charged. Of course, this law is old, circa 1967. We've eliminated the curfew laws, and you can't compare possession of drugs to a curfew violation. Anyway, they go on to say, applying the test, we have held that criminalization of passive non-conduct without mens rea makes no distinction between conduct calculated to harm and that which is essentially innocent and therefore exceeds the state's police power. The strict liability drug possession statute challenged in this case is similar to the strict liability curfew ordinance that they've talked about. And they go on to talk about some other ones, but they say the question before us today is whether unintentional, unknowing possession of a controlled substance is the sort of innocent, passive non-conduct that falls beyond the state's police power to criminalize, because unknowing possession is just as innocent and passive as staying out late with a juvenile or remaining in a city without registering. We hold that this felony drug possession statute is just as unconstitutional. Then they say, to be sure, active trafficking in drugs, unlike standing outside at 10:01 p.m., is not innocent conduct. States have criminalized knowing drug possession nationwide, and there is plenty of reason to know that illegal drugs are highly regulated. The legislature surely has constitutional authority to regulate drugs through criminal and civil statutes, but the possession statute issue here does far more than regulate those drugs. It would criminalize a letter carrier who delivers a package containing unprescribed Adderall, a roommate who is unaware that the person who shares his apartment has hidden illegal drugs in the common areas of the home, a mother who carries a prescription pill bottle in her purse, unaware that the pills have been substituted for illegally obtained drugs by her teenage daughter, who placed them in the bottle to avoid detection. A person might pick up the wrong bag at an airport, the wrong jacket at a concert, or the wrong briefcase at a courthouse. Or a child might carry an adult's backpack, not knowing it contains the adult's illegal drugs. Yes, these could be problems, but the RCW could be rewritten in a way so that it addresses that. Look, I was a cop for 9 years, and almost every time I arrested somebody who had drugs in their clothes or in their car, told me that it wasn't theirs and they didn't know it was there. They lie. They lie all the time. They are pathological liars, and they know how to abuse every system that they can with the courts and everything else. And inevitably, the drug use leads to a slew of other crimes, not just having the drugs. They got to steal stuff to pay for their drug abuse, because most of them don't have jobs. And so it just leads to all kinds of other crimes, most notably theft and burglary and that sort of thing. And there is a huge difference to having drugs in your pants than having them, in an apartment or whatever, where you didn't know that, if you share that apartment, that somebody else had it. You just can't compare some of these things that the court is drawing comparisons to. So the original report from the case this stems from is a Spokane officer who helped search a suspected chop shop in North Spokane, wrote in the documents that he was shocked at the plethora of stolen vehicles, motorcycles, and trailers at the home. They learned that there was at least one stolen vehicle at the home, returned with a search warrant, found multiple stolen vehicles and motorcycles, all in the process of being parted out or altered. A garage that housed multiple stolen motorcycles that were being worked on had a glory wall of stolen license plates hung inside. Investigators also found a shotgun, drug paraphernalia, and methamphetamine inside the home, in addition to what was found in her pants. Kenneth J. Westman was initially arrested on one charge of taking a motor vehicle without permission. On Wednesday, new charges were added, including leading organized crime, being a felon in possession of a firearm, and multiple charges of taking a motor vehicle without permission and possession of stolen property. Two other residents, Shannon Blake, who is the person in this Supreme Court case, and Jason DeFord, were arrested on a single charge of taking a motor vehicle without permission, and additional charges were expected at the time of this report. And that was October of 2016. Typical drug users. And she sounds like a real upstanding citizen, and in the court case says that her boyfriend testified that she's never used meth, even though there's meth at the house, and all this behavior is typical drug user behavior. Like I said, stealing things to sell those things to support their drug habit. That's all they do. The Supreme Court case goes on to say that such felony convictions strip defendants of many fundamental rights, both during their time of incarceration and long afterward. Drug offenders in particular are subject to countless harsh collateral consequences affecting all aspects of their lives. Yep, there's consequences for your actions. You have to pay the price for breaking the law. The state seems to be bent on making sure that that doesn't happen, that there's no consequences for any actions. Of course, they go on to say the drug statute that they interpreted has affected thousands upon thousands of lives, and its impact has hit young men of color especially hard, attributing Washington's racial disproportionate criminal justice system to disparity in drug law enforcement and drug-related asset forfeiture, among many other causes. Look, I was also a bail bondsman for 8 years and did fugitive recovery, so I've dealt with thousands of drug people, charges that they've faced in court, and they're constantly in and out of court. It's like a revolving door. They know how to abuse the drug court system, and they just know how to work the system. They know how to get around all this. They know how to keep playing it so they can continue to get out and continue to commit crimes. And the court has enabled this behavior. This decision is going to have long-lasting effects, and it's going to increase crime rate even more so than what it already has. Crime is way up, and it's going to continue to go up. It is a sad day for Washington today, I'm afraid. All right, folks, I hope you have a great day. Hey, everyone. Thanks for listening to the Behind the Line podcast. I hope you will subscribe to the channel so you can get regular updates. And if you're listening to this on YouTube, I hope you will also like it, share it, and subscribe on YouTube as well. You can find us on YouTube, Facebook, Anchor, Spreaker. We're on various other podcast platforms. And you can find me on LinkedIn under John Washington. Again, thank you for listening. We appreciate your support.